Hi, my name is Natalie. I would like to introduce my teammates for this project, which is Amir and Yee Tuck, Wong Jing Hui and Leong Vikcy. Misrepresentation is a false representation that are not incorporated into the terms of the contract, but induces the other party to enter into the contract. The effect of misrepresentation leads to the contract voidable by the innocent party. Generally, there is no duty of disclosure in English law at or before the time of making a contract.
Well, as mentioned by Natalie just now, common law principles does not require party to disclose material facts known to one party to another. However, there are certain exceptions to the general rules such as the contracts, which are being classified as überrime fide, of utmost good faith, which refers to contracts where a duty to disclose information is imposed. This doctrine centers insurance contract. It was first established in the case of Carter and Bowen and subsequently affirmed in Rosanes and Bowen, where it was held that as long as the underwriter knows nothing, it is the duty of the assured to make full disclosure to the underwriter regardless if it was being requested or not. So there are several Commercial Codifications Act that has undergone reform to meet the present of their needs, such as the Sales of Goods Act 1893, Partnership Act 1890, and the most relevant one, which is Marine Insurance Act 1906. So it has established a principle where it is applicable to non-marine and marine insurance contracts, as well as to business and consumers assureds, as seen in the case of March Cabaret Club and Casino Limited and London Assurance Limited. The Act is in place to protect the insurers where they can avoid compensation when there is a misrepresentation, non-disclosure of facts, and a breach of utmost good faith. So in the case of Pan Atlantic Insurance Company Limited and Pine Top Insurance Company Limited, it was held that there was no exception as to the duty to disclosure. Moreover, this case also raised occasions in relation to the nature of material circumstances and the effect of its non-disclosure with reference to Section 18 of the Marine Insurance Act 1906. So Section 18, subsection 1, it shows that duties are imposed as it requires disclosure of every material circumstances which is known to the assured, and the assured is deemed to know every circumstances which in the ordinary course of business ought to be known by him. So with reference to the Section 18 of subsection 2, the courts look at every circumstances that is material which would influence the judgment of the insurer in fixing premium or determining whether the risk will be taken. So this test was established to prevent insurer from unfairly avoiding compensation to the insured by asserting non-disclosure. However, though the party applied for insurance were likely to be the party with exclusive knowledge, in most cases, the duty to disclose information is mutual, which could be seen in Section 17 of the Act that imposes to either party as applied in Bank, Kaiser Ullman, and Scandia Insurance Company Limited. So moving on, other contracts that have imposed a duty to disclosure of information known to one party includes the fiduciary relationship, which is known to be connected through trust and confidence, where parties have the duty to act in the interest of another while accessing to company's assets. For example, partnerships. So complying to the general rule, parties who have fiduciary relationship are obliged to disclose important facts to the contract. So as seen in the case of Bular & Bular, the directors failed to provide information regarding to the purchase on neighboring party and came across as a passerby. So here the defendant was rendered liable as fiduciary has exploited a commercial opportunity to serve their own interests. So not forgetting that misrepresentation may arise if the statement was correct when it was made and changes to become incorrect by the time it was acted upon due to changes in circumstances which are known as subsequently falsity. The failure to disclose a change information may also result to a misrepresentation. In the case of With and O. Flanagan, the court held that where a statement is rendered false by a change in circumstances, there is a duty to disclose the change. A failure to do so will result in an actionable misrepresentation if an individual entering into a particular contract, as mentioned above, there is a duty to disclose all material facts, or else the contract will be rendered void.
some defects on the ships that we're preparing to sell.
Don't worry, boss. I think we can just cover it.
Thank you for buying.
Have a nice day.
So much.
Business with you.
Yeah, me too.
Boss, there are some defects on the ship.
What? I'm gonna sue her!
I've decided that the buyer can rescind the contract and recover the money he has paid.
In the case of Bradford's Equitable Benefit Building Society and Borders, it stated that even though a non-disclosure may be seen as a conduct that is morally wrong, however, it will not support an action of deceit. But if information has been asked for, then there's duty to disclose the truth. However, there are exceptions to the general rule. In cases which involve sales of goods, any defects need to be reviewed. Referring to the case of Schneider and Heath, seller concealed the defects of the ship before it was sold to the buyer. After the sale concluded, the buyer discovered the defects and sought to rescind the contracts, and the court held that the buyer was entitled to rescind and recover the money paid. However, in the case of Smith and Hughes, it was held that there is a contract between parties because there is no legal obligation on the vendor to inform the purchaser that he is under mistake, not induced by the act of the vendor. This was further explained in the case of Bell and Leverbros, where Lord Akin stated that failure to disclose a material fact which might influence the mind of a contractor does not give the right to avoid the contract. In a modern era, where technology is advanced, it's easy for the buyer to assess and have knowledge of the goods that he or she is going to purchase, and therefore need not for seller to disclose. However, the statutory implied term of reasonable fitness for the purpose may well be taken a view that it is promoting pre-contractual disclosure. If specific precautions are to be taken in order to use it, and these are not revealed to the buyer, it will hold the goods to be unfit and impose liability on the seller. Under the Section 14 Sub 3 of the Sales of Goods Act 1979, it states that it's enough for the buyer to make known his purpose by implication, and the statute also further explained on question of reliance. If the buyer could show that there's reliance on the skill and judgment of the seller, then the burden shifts to the seller to prove that there's no reliance. The Sales of Goods Act indirectly promotes the doctrine of pre-contractual disclosure between parties. Atia mentioned that there's still a wide range of application of the maxim caveat emptor, the principle that the buyer alone is responsible for checking the quality and suitability of goods before a purchase is made. For example, as private sales of second-hand goods. Even though sales of goods may promote pre-contractual disclosure, it will not in any way necessary to do so. This is because seller is in a position stated by statute to be exempted from liability. It's commonly known in a sales transaction, each party would try to secure the advantage for himself and try to bargain. The law recognizes that there must be some leeway in order for sales to talk. This idea is epitomized in the old expression caveat emptor, which means let the buyer be aware.
In Malaysia, there's no duty to disclosure of the material facts. Section 17 of the Contract Act 1950 provides that the act of fraud occurs when one party or its agent commits one of the following acts, which is A. The suggestion as to a fact of that which is not true by one who does not believe it to be true. B. The active concealment of a fact by one having knowledge or belief of the fact. C. A promise made without any intention of performing it. D. Any other act fitted to deceive. And E. Any such act or omissions as the law especially declares to be fraudulent. Section 17, in its explanation, explains further that the mere silence of a party from the disclosure of certain factual information does not render the act as an act of fraud. An obvious example of this is given in illustration A, where A sold an unsound horse in auction. A does not disclose the fact that the horse is unsound, and such act is not considered in law as fraud. Lauhita and Harjo Engineering, Serdam Bahar and another, the owner of a vehicle rented to it another person without informing the buyer of two relevant information, which are its manufacturing year and it has been involved in an accident. The Federal Court in its judgment observed that in laws where there is no active duty to the seller to inform all the information about the vehicle to the buyer, the seller, by keeping quiet about any defects in his product, is not considered as committing fraud under Section 17 unless he is obliged to reveal the truth about such product. However, there are two exceptions which stated in illustration of Section 17. Firstly, Section 17 sub B of the Contract Act 1950 places the position of the law in cases of active concealment of a fact on the same page as the law in Snyder and Heath. A case of fraud by concealment of material facts made by the person who has knowledge of it is case of Tay Tobok and another and Segar Oil Palm Estate Sejan Berhad. Whereas in Section 17 sub C, mere silence is equivalent to speech. For example, B says to A, "If you do not deny it, I shall assume that the horse is sound." A says nothing. Here, A's silence is equivalent to speech. In contrast, the position of the law in England is such that one party to a contract had no right to impose upon the other an obligations to reject one's offer unless the other party chose to comply with such a condition.
In addition, there is no rule imposed on the contracting party to disclose information relating to the agreement. This is disadvantageous to the consumers because some information is hidden from them. However, in some circumstances, there is certain protection for consumers stated in relevant statutes. One of the statutes is the Malaysian Insurance Act 1996. In Section 150, subsection 1 of the Act, it stated that the proposer shall reveal relevant matters to the licensed insurer which he knows to be relevant to the decision of the licensed insurer on whether to accept the risk or not, and the rates and the terms to be applied, or a reasonable person in the circumstances could be expected to know to be relevant. The exceptions are matters that diminishes the risk to the licensed insurers, matters that are common knowledge, matters that the licensed insurers know or in the ordinary course of his business ought to know, and matters in respect of which the licensed insurer has waived any requirement for disclosure. A contract of insurance is a contract uber reme fide. In order to each party to show this utmost good faith, the party must fully and completely disclose to each other matters that each knows to be material to the risk. The absence of such disclosure renders the contract voidable. The innocent party can rescind the contract and successfully refuse any attempt by the party to enforce it. In Go Chui Leong and Public Life Assurance Company Limited, the court held that the contract was voidable and the defendant was not liable because the declaration by the assured on the faith of which the policy was issued contained false statement, misrepresentation, and concealment and suppression of the truth. This case clearly illustrated the function of Section 150 of Insurance Act 1996. In Principles of Insurance Law, it stated that an insured duty to disclose material information to an insurer constitutes a duty which exists independently of any proposal forms. The mere fact that an insurer may require an insured to answer a question pertaining to the information in a proposal form does not relieve the insured of his duty of disclosure. According to Sandara Das, he stated in his book Law of Life Insurance that the disclosure must be made voluntarily, in a sense that even if the insurer does not ask the appropriate question either in a proposal form or otherwise, the insured is bound to disclose any information which is material or relevant to the risk. He must not wait to be asked. An insured duty to disclose material information to the insurers is a duty which exists independently of any proposal form. Asia Insurance Company Limited 1996. In this case, the court held that it is a general principle of insurance law that an insured is under a duty to disclose material facts, and the absence of proposal form does not modify the insured duty. The nature of a contract of insurance is one of uberime fide. Insurers are entitled to a full disclosure of all the knowledge processed by the insurers that is material to the risk. However, the duty of disclosure is not confined only to the insured. Insurers are bound by this common law duty. It is a reciprocal duty, and it is equally a duty on the part of the insurers to define the information he seeks plainly and clearly. The Uberme Fide principle is not an absolute principle to allow any form of high harness by the insurers to avoid liability. Similar issues and principles were dealt with by the federal court in the case of the Malin United Oriental Assurance Sendirian Berhad Kuantan and W.M. Mazzaro. In this case, the court held that the omissions by the respondent to state the earlier mishap in the proposal form was not his fault of the appellant company themselves for framing ambiguous question. Such ambiguity must be resolved in favor of the respondent. Although the Uberme Fide is a major development in the insurance law, but there are some lacunas which causes uncertainty.
Firstly, I'll be touching on some of the issues that have arisen within the two countries, followed by the possible reforms that may be implemented to smoothen the creases within the law of contract. To start off, I'll be diving into Malaysia's position, followed by the UK's. The first reform will be in regards to the protection against sales of defective products. Section 17 of the Contracts Act 1950 was applied to the sale of goods contract. This section provides that the seller has no obligation to disclose the defects of the goods. Status quo reflects that development of the law relating to consumer protection is a manifestation of a growing social concern to protect the weak and those unable to take care of themselves in a modern market economy in all possible scenarios. The questions then become what possible reform will address these problems. We should suggest to instill an act to protect unfair trade practices of market operators, such as protection against sale of defective, substandard and dangerous products by enforcing obligations on sellers to disclose material information, such as defects in goods, if any. This reform is necessary due to the inequality in bargaining power, which is the main justification for additional protection to this vulnerable group, which is in most cases the consumer. This is the case because, firstly, the seller, which is normally the producer of the good, on a balance of probability, will know the product better than the buyer. Secondly, if the burden is placed upon the buyer to ask questions to clear doubt, that is counterintuitive, as the buyer started off with less knowledge and thus unable to ask questions that they don't know. Therefore, we should protect the buyer in case where the seller has failed to provide the product in decent condition. This will ensure that individuals have appropriate platforms to seek protection and remedies. Additionally, it better facilitates the negotiation process between two contracting parties by ensuring that both parties have each other's best interests at heart to ensure the probability of mischief is minimized. The second reform is in the production of legislation that caters to the protection of e-consumers with the sale of goods contract. In Malaysia, sales of goods and services are increasingly being transacted over the internet, which is a borderless virtual market. This development witnesses the emergence of a new group of consumers known as e-consumers. For traders, this brings greater efficiency, increased responsiveness, and reduces cost. It enables small companies and newcomers on the market to extend their reach far beyond what was previously possible. The primary legislation governing e-commerce transaction is the Electronic Commerce Act of 2006. All in all, the ECA is insufficient as it does not adequately provide for the protection of e-consumer rights. We should suggest provisions be created on how electronic transactions will be done in a safe and secure environment, which is crucial for e-consumer protection. Whilst the generally law on contracts and sales of goods contract can be found in Contracts Act of 1950 and the Sales of Goods Act 1957, these laws are rather outdated and have not yet been amended to suit modern business transactions. Thus, we do update both legislations to better fit the modern society. Moving onwards, we'll address the UK's position. The English law position on disclosure has been described as poorly understood, which leads to a widespread of failure to provide material information. In light of these shortcomings, the Insurance Act 2015, UK repealed Section 18 220 of the Marine Insurance Act of 1906, and so dispense with the duty of utmost good faith in the context of the insured's pre-contractual duties and replaced it with the concept of fair presentation. Professor J.T. Farran, in his journal Real Property, Looking into Property, contracts, there is an express term of the contract requiring the disclosure of the matters there stated possibly where there is a latent physical defect which might endanger the purchaser's life or cause serious financial loss. For example, where an amateur has put his own central heating into a restaurant, but there is a latent physical defect which involves also a latent defect in the title, such as the sewer under the land, which is vested in the local authority, concealment of a defect which may conduct amount to deceit or at least innocent misrepresentation. There is a possible implied obligation to disclose planning restrictions, negligent misstatement based upon the failure to use with due care the special knowledge of the maker of the statement, as in overstating the potential of a business, and possibly the obligation on parties under a subject to contract agreement to negotiate in good faith. Taking this into account, maybe it can be termed in the contract where both parties must disclose all material facts during negotiations in areas where the subject matter is relevant to the contract. This is where, if undisclosed, either one of the parties would be suffering a loss or could lead to misrepresentation. Perhaps the most crucial problem within contract law is that the law at times is not coherent in seeking the enforcement of moral standards which require complete honesty during the process of negotiation that leads to the formation of contract. It is hard to uphold the moral obligation and the self-interest of the parties in contract law. However, the exceptions are guarded under the statutes and common law in England and Wales, as well as Malaysia, have imposed specific disclosure obligations. Nonetheless, a better approach may be promoted in contract law within both jurisdictions if certain reforms are implemented.
In conclusion, there's no general duty of disclosure in either jurisdiction. This is so because mere silence is insufficient in itself to support an action for deceit. Something more is required for the silence to constitute misrepresentations, such as the active concealment of a defect. There are three common exceptions to the general rules, which are the contracts of oberrime fidei, relationship of a fiduciary nature, and those created by a statute. Malaysian law is stricter in the sense that it imposes a moral obligation on the part of the representee to, insofar as it is practicable, make sure the representation was true. This is the duty of ordinary diligence. However, it is also broader in the sense that it includes situations where silence is equivalent to speech. Thank you.